In this video, I am making a breakdown of the judgment of the Federal High Court that convicted Nnamdi Kanu and sentenced him to terms of imprisonment. To also look at the way forward for Nnamdi Kanu. This is Nnamdi Kanu, the leader of IPOB. He was convicted by the Federal High Court a few days ago. Date of judgment, 20th November 2025. Judge Justice James Omotosho. Let's look at the timeline for the trial. On October 14, 2015, Nnamdi was arrested in Lagos by the DSS. DSS is the Secret Service of Nigeria, right? On November 23, 2015, Nnamdi was arraigned at the Magistrates Court, Abuja. That means he was flown from Lagos to Abuja, where he was arraigned at the Magistrates Court. He was later transferred to the Federal High Court, Abuja, and charged for terrorism charges. On April 25, 2017, he was granted bail on health ground in the sum of 100 million naira. Remember that bail that was signed by Senator Yinaya Baribe, the senator representing Nnamdi Kanu in the Senate of Nigeria. So Yinaya Baribe signed the surety, and Nnamdi was granted bail. On April 28, 2017, he fulfilled all the conditions of the bail, and then he was allowed to leave Kuje prison. In September 2017, the military invaded his father's residence in Umuahia. People were killed, others were wounded. Nnamdi escaped and then ran away from Nigeria. The case in court was thus stalled for about 4 years. Nnamdi was outside the country, and so the case was not heard anymore. In 2021, Nnamdi was renditioned in Kenya and flown back to Nigeria to continue with his trial. Nnamdi later accused the trial judge, Justice Binta Nyako, of bias, and the matter was assigned to another judge, this time Justice James Omotosho. Right? In between this, Nnamdi's legal team had taken the matter to the Court of Appeal, and at the Court of Appeal, Nnamdi was discharged at the Court of Appeal. The trial was set aside for reason that his arrest in Kenya was unlawful. That was the reason given by the Court of Appeal, that his arrest in Kenya, the way and manner he was arrested, extraordinary rendition, was unlawful. I think it was Michael Zokeme, Senior Advocate of Nigeria, that argued that matter for him at the Court of Appeal and then won. The federal government of Nigeria went further to the Supreme Court, appealing the judgment of the Court of Appeal. And at the Supreme Court held that though his extraordinary rendition in Kenya was unlawful and against international law, it nevertheless did not invalidate the charges against him in Nigeria. I hope you are noting this point, because one of the narratives is that Nnamdi was discharged at the Supreme Court. What the Supreme Court said was the extraordinary rendition was unacceptable. It was against international law. We agree that it was wrong, okay, for him to have been taken that way from Kenya to Nigeria. However, that the wrong procedure did not invalidate the criminal charges against him in Nigeria. The case was then returned to the Federal High Court for continuation of trial. On March 21, 2025, Nnamdi's trial before Justice James Omotosho commenced. The judge ordered for accelerated hearing, and the matter was heard from day to day, almost like every day or two days, but there was no week that the matter was not heard. From March till October 2025, the matter was concluded, about 6 or 7 months. Now, upon the close of the case of the prosecution called 5 witnesses, mostly personnel of the DSS that said they had investigated the matter. Upon the close of the case of the prosecution, Nnamdi offered to defend himself in person. He let go of his legal team. Nnamdi later insisted that there was no charge against him, and that he will not enter any defense nor call witnesses. Remember that Nnamdi had listed a number of witnesses that he was to call. One of the witnesses was Nyesom Wike, the minister of the FCT. Another witness was the former Attorney General, Malame, and other persons that were listed by him. But he said, my Lord, I'm no more calling them. I don't want to even open my defense because for me, there is no charge against me. The law upon which I am being charged is a repealed law. The judge asked him to defend himself, but he stood his ground and said he doesn't have any defense. He doesn't have any charge against him, and therefore there is no need for defense. The judge then foreclosed him and proceeded for judgment. On November 20, 2025, judgment was delivered by Justice Omotosho, and the judgment was beamed live on televisions, the major television platforms, and it could be viewed from all over the world. What was the verdict of the court? What did the court say in the final analysis? I have read the judgment. The judgment is 144 pages. I have read it from page 1 to the last page. So, at page, 147 pages, I think so, 147 pages. At page 146 of the judgment, the judge held as follows. 1. That Nnamdi Kanu is hereby sentenced to life imprisonment on count 1, 2, 4, 5, 6. Life imprisonment. 2. That Nnamdi Kanu is hereby sentenced to 20 years imprisonment for count 3 without any option of fine. 3. That Nnamdi Kanu is hereby sentenced to 5 years imprisonment with no option of fine in respect of count 7. Now, Nnamdi was charged to court before Justice Omotosho on 7 count charges. What does it mean? 7 heads of counts. 1, 2, 3, 4, 5, 6, 7. Each of these counts had separate offenses, separate charges. Right? And from these verdicts, you can see that the judge found him guilty on all the 7 counts, all the 7 charges. Right? We continue. 4. The judge also held that the sentence shall run concurrently, effective from the day of judgment. What does it mean to run concurrently? It means it will run at the same time. You don't finish serving 20 and then start 5. All of them will be subsumed into the same period. So by the time you serve 20, you would have served at the first one, the shortest, which was 5. Right? That is what it means to run concurrently. 5. That Nnamdi Kanu shall be kept in protective custody in any custodial center in Nigeria. That means in any prison custody in Nigeria. 6. That Nnamdi Kanu must not be given any digital device. And if he must, it must be closely monitored by the Office of the National Security Advisor. Number 7 of the verdict of the court was that the radio transmitter and related equipment that was seized from Nnamdi Kanu by the DSS should be forfeited to the federal government of Nigeria forthwith following the judgment. Now, let's do the explainer. Okay? You've heard mention of count 1, 2, 3, 4, 5, 6, 7. And so the question is, what were these counts talking about? We begin with count 1. Count 1 said that you, Nnamdi Kanu, male adult of Afaroku, Ibeku, Umuahia North Local Government area of Abia State sometime in 2021, being a member and a leader of IPOB, a proscribed organization, did commit an act in furtherance of an act of terrorism against the federal government of Nigeria and the people of Nigeria. Note, by making a broadcast received and heard in Nigeria within the jurisdiction of this court with intent to intimidate the population and threatened that people will die and the whole world will stand still. and that for that reason you have committed an offense punishable under Section 1 Sub 1 of the Terrorism Prevention Amendment Act 2013. That was count 1 that was leveled against Nnamdi Kanu. And what was the verdict of this count 1? Life imprisonment. So it was this count 1 that the judge said, you are guilty of this, and therefore I sentence you to life imprisonment. Let's look at count 2. That you, Nnamdi Kanu, sometime in 2021, did commit an act in furtherance of an act of terrorism against Nigeria and its people when you made a broadcast, again, broadcast, which was received and heard in Nigeria with intent to intimidate the population and issued a deadly threat that anyone who flouted your sit at home order, sit at home, should write his will, which led to the closure of banks, schools, markets, and stoppage of vehicular movements in eastern Nigeria, and you thereby committed an offense punishable under Section 1 Sub 2 Sub B of the Terrorism Prevention Amendment Act 2013. Also note this, 2013, right? Now, what was the verdict of this, of the court regarding count 2? Still life imprisonment, because the judge said that he's guilty of this count 2. Count 3, that you, Nnamdi Kanu, on diverse dates between 2018 and 2021, professed yourself to be a member and leader of IPOB, a proscribed organization in Nigeria, and you thereby committed an offense contrary to and punishable under Section 16 of the Terrorism Prevention Act. So this one has to do with being a member and leader of a proscribed organization according to the prosecution, and that is the text of count 3. And what did the judge say about this? Judge found Nnamdi guilty, and the verdict of the court was 20 years imprisonment. Note that the first 2 counts, life imprisonment. This one is 20 years imprisonment. Let's look at count 4. That you, Nnamdi Kanu, on diverse dates between 2018 and 2021, made a broadcast, again, broadcast, received and heard in Nigeria in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which broadcast you incited members of the public in Nigeria to hurt and kill Nigerian security personnel, and you thereby committed an offense punishable under the Terrorism Prevention Amendment Act 2013. Note again, 2013. So this was count 4. And what was the verdict? Life imprisonment. Let's look at count 5. 5. That you, Nnamdi Kanu, on diverse dates between 2018 and 2021, made, again, a broadcast received and heard in Nigeria. Okay, saying wherever you made the broadcast, the transmitter was received in Nigeria and heard in Nigeria, in furtherance of an act of terrorism against the federal government of Nigeria and the people of Nigeria, in which, note, you incited members of the public in Nigeria to hurt and kill families of security personnel. You know, the other one was hurt and kill the security personnel. So this one, the prosecution is saying to hurt and kill families of Nigerian security personnel, and thereby committed an offense punishable under the Terrorism Prevention Amendment Act, again, 2013. And what was the verdict of the courts? Life imprisonment. If you observe, any charge that mentions terrorism, okay, the sentence is life imprisonment. 6. That you, Nnamdi Kanu, on diverse dates between 2018 and 2021, made a broadcast received and heard in Nigeria in furtherance of an act of terrorism against the federal government of Nigeria and the people of Nigeria, in which you directed members of IPOB, a proscribed organization, to manufacture bombs, and you thereby committed an offense punishable under Section 1 Sub 2 of the Terrorism Prevention Amendment Act 2023. What was the verdict? Again, life imprisonment in respect of count 6. What is count 7? That you, Nnamdi Kanu, on diverse dates between the month of March and April 2015, imported into Nigeria, importation, into Nigeria and left in Obiliziozu village, in Ihiala local government area of Anambra State, a radio transmitter known as Trans 50L, concealed in a container of used household items, which you declared as used household items. You did not declare it as transmitter, and you thereby committed an offense under section 47 sub 2 of the Criminal Code Act 2004. It is this very count that the Supreme Court said you have to go and correct, because the Supreme Court said that this is not the correct law. Criminal Code Act is not the correct law. That the correct law for this offense is customs and excise law, importation of goods without declaring what it is. So that is what the Supreme Court said, go and effect the correction. The Supreme Court also said that even when you are charging somebody under a wrong description of the law, it does not invalidate the charge, right? Now, what is the verdict of the court on this? 5 years imprisonment with no option of fine. So basically, these are the 7 counts that Nnamdi Kanu was tried for, and the court found him guilty for all 7, and then he gave sentencing, punishment for each and all of them. Now, in arriving at the verdict of the court, the judge held that Nnamdi failed to counter the witnesses of the prosecution and is therefore deemed to have rested his case on the case of the prosecution. That there being no defense, the court is bound to accept the allegations of the prosecution as proved. That the prosecution has proved his case beyond reasonable doubt, hence the conviction. So the judge was basically saying that he had given Nnamdi the opportunity to defend himself. That with this kind of charges, Nnamdi should have said something in his defense. Even if Nnamdi did not want to use his lawyers anymore, he should have even defended himself by himself. Transmitter, for instance, was it declared? If there's evidence, you show it to the court, and that charge will go. That charge will be cancelled. Broadcast, did you make any broadcast? If you did not, you show to the court that you did not, and the charge will be cancelled. And so the judge said that the evidence of the 5 witnesses of the prosecution was not in any way controverted, countered, discredited by Mazi Nnamdi. And for that reason, the law says that he is allowed to arrive at the conclusion that Nnamdi has no defense, right? People have argued about the fact that he should have had a defense. Others have said he did not need to have a defense. It depends on how one is looking at it. So let's look at the available options for Nnamdi Kanu. This is Nnamdi Kanu with his last lead counsel in the matter, Chief Kanu Agabe. Kanu Agabe is a senior advocate of Nigeria. Kanu Agabe is a former Attorney General of Nigeria, well respected in judicial circles. The first option is for him to appeal against the judgment. You move from the trial court to the Court of Appeal. He can do that in any Court of Appeal. Judgment was delivered in Abuja, so he can do it in the Court of Appeal Abuja or in any division of the Court of Appeal that he chooses, right? The law gives him 90 days to file a notice of appeal, right? This time has already started running. The time has started counting. From the day of the delivery of judgment, 90 days begins to count. By 91 days, he would have been out of time. But 90 days is a long time for him not to be out of time. I don't expect him to be out of time. It's a serious matter, so he needs to get the notice of appeal filed immediately. 3, he can file the notice of appeal by himself or by a legal practitioner of his choice. The law allows him to file the notice of appeal by himself. He can do it. Just as he defended himself in the trial court, he can as well decide to file his appeal by himself and defend himself by himself. The law allows that completely for him. 4. Note that appeal is the rehearing, otherwise known as review, of exactly what transpired at the trial court, as contained in the record of appeal, without more. You are not allowed on appeal to add anything. You are not allowed on appeal to say anything new. You are to puncture what was done at the trial court. That is your role as an appellant. You cannot bring a new document. You cannot open defense in the court of appeal. Are you getting me? So, appeal is the rehearing. Lawyers would understand. It's a review of what happened at the trial court only. You are to make sophisticated legal arguments to puncture the decision of the trial court. You are not to bring anything new to the court of appeal. Before you can bring anything new, the law is that you must show that that new thing was not available at the trial court at the time of the trial. So, appeal principally is a review of what was done at the trial court. And that is why I normally say, whatever you need to do at the trial court, do it. Let it be on record. It will help you on appeal. No new point of law or argument is allowed at appeal. 5. Depending on the outcome of the appeal, Nnamdi has the right of further appeal to the Supreme Court. Right? Likely outcomes. Let's look at what will be the likely outcomes of the appeal when he files and argues. Okay, this is Nnamdi Kanu. This was his last appearance at the Supreme Court of Nigeria, where he went to submit a letter to the Chief Justice of Nigeria. That I'm sure this is the reception of the Chief Justice of Nigeria, where he went from the DSS custody to submit his letter to the Chief Justice of Nigeria for her intervention and for possible arrest of judgment. But there are many pronouncements of the Supreme Court that doesn't allow the arrest of judgment once the judgment is set for hearing. Okay, we discussed that some other day. So what are the likely outcomes? Discharge and acquittal. The Court of Appeal can accept the argument of Nnamdi Kanu and discharge him and acquit him completely. If that is done, Nnamdi goes home a free person. 2. Upholding the judgment of the trial court. So the Court of Appeal can also say, well, we have listened to your argument, but we are not persuaded enough to set aside the judgment of the trial court. The law is stacked against you. For that reason, we are upholding the judgment of the trial court. Now, 3. If number 1 happens, Nnamdi goes home a free person. If he's acquitted and discharged, he goes home. No further charge. If number 2 happens, that is, if the judgment is upheld, Nnamdi will remain in custody and make a further appeal to the Supreme Court. If 1 happens, he goes home. If 2 happens, he will remain in custody, but still has an opportunity to make a further appeal to the Supreme Court. Now, can he be granted bail pending appeal? I'm sure this is the next thing that should occupy the minds of his lawyer. I have talked about appeal, that he can do it himself, but I also would suggest, I would recommend that he should engage the services of lawyers in the appeal. Appeal is like, we did maths in secondary school. Appeal is like further maths. You need to apply forensic thinking into appeal to be able to strike and get it. So I would recommend, but subject to Nnamdi's decision, let him use lawyers that are experts in criminal appeals. So, can he be granted bail pending appeal? The answer is yes. He can be granted bail. The law allows the grant of bail pending the determination of appeal. So Nnamdi can apply to the Court of Appeal for him to be granted bail. He said he's not going to run, that he will make himself available. He can accept to drop his international passport and every travel document, that he should be granted bail. And if properly argued and the court is convinced, he can be granted bail pending appeal. It's possible in law. But when the sentence of death or life imprisonment is involved, right, the law presumes that the person might abscond if granted bail, and therefore the grant of bail will be difficult. It will only be on exceptional circumstances properly presented to the court before you can be granted bail if the sentence against you is that of death or life imprisonment. Because, I mean, if you have sentenced someone to death or life imprisonment, it's natural that the person, if he's granted bail, he will want to escape and be alive and have freedom. So the law says it will be difficult to grant bail when that is the pronouncement, but it is not impossible. Bail can still be granted, provided you have given reasonable justification and what is called exceptional circumstances to the court. Now, such exceptional circumstances could be serious illness that the prison authority is unable to treat. They don't have the facilities in their prison custody to treat a particular illness. And there is medical reports to show that this person needs to be taken abroad for treatment. That way, if the court is convinced, bail can be granted. If there is high probability of success on appeal, the Court of Appeal can also easily grant bail. If the Court of Appeal looks at it and says that, oh, the trial court did not even have jurisdiction to have tried this matter. Nnamdi has been talking about repeal. So if the Court of Appeal says the law was repealed and agrees with Nnamdi that the court had no jurisdiction to try him on a repealed law, then the court can grant him bail pending appeal, but it is left for the Court of Appeal to say that. Now, nothing stops his lawyers from making an appeal to the Court of Appeal for bail. Nothing. Even today. Right? But while the appeal is yet to be transmitted to the Court of Appeal, his lawyers can as well apply to the trial court to grant him bail. Are you surprised to hear that? It can be done. You go to Justice Omotosho's court and apply for bail of Nnamdi Kanu pending appeal. Okay? But the law also requires that you present exceptional circumstances to Justice Omotosho before bail can be granted by him. So bail can either be granted by Justice Omotosho, or you wait, transmit everything, present it before the Court of Appeal, and then you apply for the bail of Nnamdi Kanu if exceptional circumstances are given and the court is fully satisfied. Bail is not impossible to be granted to Mazi Nnamdi Kanu. The coming days, the coming weeks, and the coming months will be very revealing as to the fate of Nnamdi, as to the steps to be taken by Nnamdi and his legal team, if he chooses to have a legal team working with him. As events unfold, we shall continue to give these lectures, break down issues of law for the understanding of non-lawyers. My target audience is the non-lawyers, because I know that lawyers perhaps would have understood these procedures already, but there's nothing wrong in lawyers also, refreshing their minds on these issues of law. Many thanks always for watching.